Minister Kubayi about how this issue of judicial independence will be rolled out over the next little while. And so this discussion is particularly relevant for those purposes. Now, I will be facilitating, or I'll be directing the program for today, but the conversation obviously belongs to all of us. Minister Kubayi has kindly agreed to give us 2 hours of her time on a Saturday morning away from her family. So we will try to maximize the time that we have with her this morning. Just a little bit of housekeeping. So all of our videos, or for most of our videos, will be switched off, and our mics will also be switched off. So for the purposes of questions, we will encourage you to please post the questions in the chat. I will be posing some of those questions to Minister Kubayi, and she will try her best to give us her full responses, and we will try to get your questions answered in the conversation. The main conversation will be facilitated by my colleague, Alison Tilley. I will also chip in here and there, but the conversation is for all of us as participants this morning. So without further ado, I will just like to give a brief introduction to the Minister and to Alison, who is our facilitator this morning. But before I do so, I thought I should share a little bit about who we are as Judges Matter. So Judges Matter is part of the Democratic Governance and Rights Unit, which is an applied research unit in the Faculty of Law at the University of Cape Town. We like to think of ourselves as Africa's leading think tank on the judiciary. Judges Matter has 3 main programs which carry its work. The first one is, sorry, the DGRU, not Judges Matter, but the first program under DGRU is Judges Matter. The second one is the Judicial Institute for Africa. The third is the African Legal Information Institute, which is African-LI. And these programs all carry different responsibility at the DGRU. So Judges Matter does research and advocacy for legal policy and practice reform in African judiciaries. GIFA is responsible for training and development for judicial officers and other allied professionals in judiciaries across Africa. In the last 2 weeks, GIFA actually has been running training courses for regional courts, ECOWAS for the West African community, and COMESA for the East African community. So GIFA is also proud to have the first postgraduate diploma, postgraduate course on judicial studies in Africa. And then lastly, African-LI, the African Legal Information Institute, provides access to legal resources, which is case law, legislation, gazettes, and bylaws across Africa. African-LI currently does so in 16 African countries, including South Africa, where we have the lawlibrary.org.za, and we are hoping to branch off into West Africa and French-speaking Africa in particular. So those are the 3 programs under the DGRU. Now, today we are hosted by Judges Matter. Judges Matter obviously does a lot of work in South Africa, but we also do work in the SADC region. So our focus as Judges Matter is on mainly judicial appointments, judicial conduct, judicial governance, and the way that we do so is through academic research, as we are part of an academic institution. We do monitoring, and so we sit in the interviews for judges. We sit in the tribunals that are there for judges and magistrates, and we also sit in the interviews for magistrates. In fact, this week, we were in Pretoria at the Magistrates Commission to monitor the interviews for magistrates. We also do a lot of public advocacy, so you will see us in the media. My colleague there, Zikona, was a part of us until she left us recently. And of course, for the last 6 years that she was at Judges Matter, she got a bit of a gray hair because of the workload, but that is the work that we do as Judges Matter. Now, a little bit about our guests this morning. So our first guest is Minister Mmamoloko Kubayi, who needs absolutely no introduction, but I will do so anyway. Minister Kubayi is the Minister of Justice and Constitutional Development, which is a portfolio that she's held since December last year. She's also the co-chairperson of the Justice, Crime Prevention and Security Cluster in Cabinet. She has been a member of Parliament since 2009, and she served in various portfolio committees in the National Assembly, where she's also been a whip and the chair of the Communications Committee. She's also served in various portfolio in the executive, and I think, Minister, you'll correct me if I'm wrong here, but I think you hold the record currently of having held the most cabinet portfolios of all ministers in the government currently. She's been a member. She's been a minister for tourism, for science and technology, for energy, communications. Recently, she was the Minister for Human Settlements. And I think for some of us will remember, she was acting minister during the COVID-19 pandemic, Minister of Health. And I think, Minister, a few days after you were appointed, you were already doing those COVID briefings on the Saturday, which is really impressive. Minister Kubayi has been a member of the African National Congress National Executive Committee since 2017. She holds the BA and BA honors degree from the UJ, a postgraduate diploma, and a Master of Management, which she graduated with recently and officially became a VITSI like me. She's a PhD candidate at the University of Johannesburg, and we are really delighted to have you, Minister. I think you and I share the honor of being from Soweto, so it's glad to have a fellow Sowetan on the call. And then our next guest is Ms. Alison Tilley, whom a lot of us will know, having seen on TV. She's the coordinator of Judges Matter. She's a member of the Information Regulator of South Africa, a founding member, I should say. She has a long career in issues of information law, in constitutional law, transparency issues, whistleblowing, privacy and accountability issues. She was a former director of the Open Democracy Advice Center. She holds various qualifications, a BA in LLB from UCT, and she's also an admitted attorney of the High Court of South Africa. So just to run through how we are going to run today's session. So I will obviously do the introductions as I've done, and then I'll hand over to the minister just to give us a brief opening remarks, just for 5 to 10 minutes, and then I'll hand over to Alison Tilley, who will begin with our discussion today. After Alison finishes her discussion, I'll jump in with the questions and answer. Again, please post your questions on the chat so that we are able to facilitate the Q&A with the minister. And then lastly, I will invite the minister once again to give us her closing remarks, and then we will quickly close. We're hoping to run this session until 12 o'clock. So if you can please keep your questions as brief as possible. That will help us in getting as many questions as we can. And then this session, again, I should remind you, will be recorded. And so we will post it on the Judges Matter YouTube page. If you still want to rewatch it, or if someone who couldn't be here today is also interested, you may please share it with them on that platform. Without further ado, I will hand over to you, Minister, to give us just a brief opening remark for about 5 minutes, hopefully, but we can stretch it to 10 if you're nice.
Thank you very much, Mbekezeli, and good morning to you. Good morning, Alison. Good morning to all those who have joined us on the platform. Great to be here and looking forward to the conversations this morning. Just to start with a quote by the President during his Constitutional Hill address as we celebrated 30-year anniversary of the Constitutional Court. President Ramaphosa made the following observation. The bench, and I quote, the bench, not unlike any other sector in society, will have borne witness to the many debates around transformation, around judicial demographics, and around access to the courts by citizens. The court has at times found itself dragged into political controversies and has had to manage occasional friction with the executive over the separation of power. And yet, amidst all this, the Constitutional Court has not been shaken but stood firm as a credit to the democratic order. What has defined the Constitutional Court that we are proud of is not just the wisdom of its judges and judgment, but the courage of its conviction. It has withstood political pressure, defended the separation of power, and asserted that no other person or institution is above the Constitution. It has done so with a steady voice, grounded in reason, compassion, and principle, unquote. This was a correct observation, and it bears testimony to the judicial independence in which our courts have enjoyed in the more than 30 years of democracy. The judiciary has been at the center of a new rights-based society in the making, which it has shaped and also been shaped by it. Our courts, especially the Constitutional Court, have been able to be a steady voice grounded in reason, compassion, and principle without interference from the executive, even in cases where the executive vehemently disagreed with the decisions of the court. And Mbekezeli, just this week, people were hoping that I had the powers to reverse the surname decision, because many men were not happy about that and thought that they had been forced. So we had to explain that, no, this is not a force, it's a voluntary. But they wished that we can reverse that and continue to remind them that the executive does not have powers to change the decisions of the courts. The debate on judicial governance and court administration within the context of an independent judiciary has been ongoing since the advent of democracy. The principle of the separation of power and the independence of judiciary lie at the heart of this debate. Constitution entrenches and guarantees the independence of the judiciary, and at the same time mandates all organs of state through legislative and other measures to protect courts, to ensure their dignity, impartiality, accessibility, and effectiveness, as per the section 165 subsection 2 and subsection 4 of the Constitution. Institutional reforms relating to judicial governance and court administration constitute part of judicial transformation packages aimed at establishing a judicial system suited for a constitutional democracy as mandated by the Constitution. A meeting was convened by the President on the 6th of June, and I must hasten to say that since my arrival in the portfolio, there's been consistent interaction between ourselves as the executive and the judiciary, led by myself in terms of the ministers and also the team. So we had to do a thorough preparation towards the meeting on the 6th to look at where the journey we've traveled in terms of our country, but also what needs to be done so that we make the meeting with the President effective. So on the 6th of June 2025, the executive, led by the President, the judiciary, led by Chief Justice Maya, held a meeting to advance the process to ensure institutional independence by accelerating efforts to create a single judiciary and enhancing the capacity of the Constitutional Court, Supreme Court of Appeal, and High Courts, but more importantly, to ensure that we can start the process of full independence and Chief Justice-led administration. So sequel to this meeting, it was agreed that a task team comprising the executive and the judiciary would work would guide the process of transferring identified function from the Department of Justice and Constitutional Development to the Office of the Chief Justice, as well as work towards drafting a bill that would serve as the enabling legislation to facilitate the institutional independence of the judiciary. The process has been initiated with the understanding that the Constitution dictates that the governance of the judiciary and administration of court placed under the authority of the judiciary has to be placed under the judiciary itself. In this respect, judicial independence includes institutional independence, which can only be achieved if the judiciary enjoys structural independence, including financial and operational independence. In both the Clinester and Sonke judgments imposes an obligation on the state to take reasonable steps to establish and maintain independent bodies to safeguard fundamental rights. Independent institutions must be funded by Parliament, free from executive control, Accounting officers of independent institutions should be accountable to Parliament and not to a government department. Currently, Section 54, subsection 1 of the Superior Courts Act 2013 empowers the Chief Justice to make requests for funds needed for the administration of the courts after consulting with the heads of courts. This request should be submitted to the minister, who must consider and address such request. The judiciary argues that Section 54, subsection 1 of the Superior Courts Act leaves the minister as the gatekeeper of the OCJ's budget making. The prevailing belief is that the current OCJ funding model is at odds with the requirement of financial independence. It is for this reason that the current process led by the task team is aimed at conferring the judiciary with full scope of competencies required to perform its functions, such as HR management, effective maintenance of on-court building, procure goods and services, including capacity to tender, adjudicate bids, and acquire equipment, furniture, technical systems, and other assets. Secondly, the judiciary must be capacitated by similar legislation framework applicable to Parliament, such as the Financial Management of Parliament. Under the FMPPPLA, both Speaker and Chair of the NCOP are jointly the executive authority over Parliament and are accountable to Parliament to ensure sound financial management. Secretary of Parliament is the accounting officer accountable to the executive authority, which is the Speaker and the NCOP Chair. An oversight mechanism has been established to maintain oversight over the financial management of Parliament. National Treasury and the Minister of Finance assume a consultative role when budgetary proposals for Parliament are submitted. A substantial similar dispensation should be enacted for the judiciary. Under this model, it is proposed that the Secretary General will appear before committees of Parliament to account for the finances. The enabling legislation must provide for financial and operational independence of the superior courts, administration of promoting governance mechanisms and appropriate checks and balances. But more so, not only superior court, but all courts. OCJ should be a permanent independent entity separate from the executive authority under the aegis of the judiciary. So meaning that with what we're looking at, the Minister of Justice and Constitutional Development will cease to be the executive authority over the OCJ, and the judiciary will look into this. I must hasten to say, one of the issues that is a bit sticky point that we will have to go into detail and look at is to say who becomes the executive authority. Because in terms of PFMA, the executive authority does bear some level of responsibility and accountability, but also is expected to appear before Parliament. So if we are to say, if the proposed legislation ends up saying the Chief Justice is the executive authority, it means the Chief Justice must appear in Parliament, which some of the colleagues are saying it's not an ideal situation. So a proper mechanism has to be found to be able to address this area of work, and we are in consultation in that regard. OCJ will require to administer and provide support to the courts generally, including but not limited to the provision of information technology. These are administrative support, corporate and logistics services. So what it means that what we want to do is going broadly beyond where they are sitting now, but full independence in terms of the work that they have to do. And the OCJ becomes that administrative arm. And one of the issues is to look, even for example, you'd have to look at the Secretary General of the OCJ, not to be at the level of the Director General, but different, maybe take the format as well. We're looking at the format of the Parliament, where the Secretary of Parliament, in terms of even the package remuneration, but also authority and responsibilities going beyond what you would have in normal departments. So since the formation of the task team, the work on the transition to administrative and operational independence of the judiciary, significant progress have been made to make this vision a reality. It has been agreed between the department and the OCJ that the transfer of functions from the department to OCJ should be done in phases. Phase 1 will involve the immediate transfer of shared services relating to the superior courts from the Department of Justice and Constitutional Development to OCJ. These shared services are not provided for in any legislative instrument and the transfer could be effective through a directive from the minister to the accounting officers of the department and OCJ. And that would mean that the Minister of Finance would not put those financial, will not put that budget in the Department of Justice, but it will go directly. And with this mechanism, it's easy to do, and that's why we've termed it the phased one approach, and the phased approach and phase one implementation. And this, we're looking at implementing it from the 1st of April, with those responsibilities being transferred. Phase two involves, amongst others, the operationalization of the legislation aimed at clothing the judiciary with full institutional independence, including the creation of a single judiciary. As you know, today, the lower courts are actually in the responsibility of is currently the responsibility of the minister. So we'll have to do the legislative amendments so that that can be also be able to be moved under OCJ and under the judiciary to be able to create that single judiciary. With this regard, it means that even in terms of magistrates, so that their remuneration, their conditions of work, the courts themselves, lower courts, and the staff in the lower courts, because currently those staff are the staff of the Department of Justice and Constitutional Development. There would have to be a work needs to be done. That's why we call it second phase, to be able to engage with the union, engage with the staff, because that they will be transferred out of the executive, out of the departments into the judiciary, including all those. Then the conditions of work will change, and that's the second phase that we'll have to do. So that's one of the issues that we're looking at in terms of even the streamlining to be able to ensure. However, in line with the vision of creating a single judiciary, we believe the transfer of the lower court to the OCJ will make the judiciary stronger and independent as the third arm of the state. To this effect, an audit of court-related functions to be transferred to the OCJ has been conducted, which indicates that the Magistrates Commission and various functions performed in respect of courts operations at national and provincial level should be transferred to the OCJ. So this would be the work that we do, and we do understand that this is not going to be one of the easy one. It's going to be taken. That's why would be our last phase as we transfer these responsibilities, the employees, including, because most of the time you're looking at where are the shared services, you'll find that in the province, the provincial head of the Department of Justice and Constitutional Development will be responsible for certain responsibilities in the department, but also in relation to management of our courts and overseeing that work. What we would have to do is to repurpose their positions to be able to separate the responsibilities. So meaning job profiling once again of the entire organization, both in terms of the judiciary and in terms of that. And one of the issues is that we've started to agree that there are mechanisms that we put in place so that if there are posts that are going to affect or later become in the judiciary, they will not be filled by the department, so that we can be able to ensure that as we transfer, there are no difficult choices that we have to make. But there are responsibilities, because we still have to ensure that we remain with the responsibility of ensuring that we can do our work. The last point I want to make here is that in terms of the constitutional responsibility of the Minister of Justice, because that remains, and we've also agreed between ourselves and the judiciary that access to justice remains that we have to be able to oversee. So there are constitutional requirements in terms of how the rules are done, consultation with the executive, as part of representative of the people. Our presence in the judiciary and the Judicial Service Commission will remain, because it's still within the ambit of ensuring that all of us can function in one, but also the checks and balances that the Constitution provides remains one of the issues that we want to deal with. As I conclude, I said, I want to reaffirm on behalf of the executive our commitment to safeguarding and supporting the independence of the judiciary. We also committed to creating a single judiciary that is administratively and operationally independent and led by the judiciary. Thank you.
Thank you very, very much, Minister, for those opening remarks. You've given us a mouthful, actually. We've much more than we bargained for, but we are grateful for those insights. I do have a couple of questions that I already have in the list, and Alison will also add a couple of questions, I'm sure. But I would also like to encourage everyone who is on this platform to also share their questions in the chat function. The chat is just below this meeting. So if you can't see it, please let us know. But we are grateful for those opening remarks, Minister. I will then hand over to Alison, who will start our conversation with the Minister. I think, Alison, the Minister has covered a lot of ground, and I'm keen to hear where you will start. So, Alison, you can go ahead.
Thank you very much, Bex. Yes, wow, that's a lot. And so many of the issues that I think have been raised are really spoken to in the address you've given us. I think one of the questions that I have, and I don't know if it's a question that really can be answered, but I'd be interested in your thoughts, Minister. The question of budgets, I suppose. A lot of the discussion, as I think you've indicated, is around this question of, of who manages the money, who controls the purse strings, and there's this view that if we create a system where the OCJ then manages the budget rather than DOJ, that would lend itself to institutional independence. And I mean, I completely agree with that. But one of the issues that I think we hear from the judiciary and the magistrates is that there are really just not enough resources, and the question goes through from infrastructure to people to salaries, and you'll have heard that discussion. Do you think these changes would really make a difference in terms of the level of resourcing? Do you think there will be savings that are affected by this? And how, if there are no savings, how would we increase the resources that are available, given that and especially things like the number of judges and the number of magistrates? I was wondering what your thoughts are on how that will play out.
Alison, I think the first issue I want to say is that we all going to have to take from the same pot. So what revenue can provide is what would have all of us have to utilize. And most of the time, I guess the issue is that the money that is there, where is it directed to? Because majority of it is directed towards not the administration or support to the executive, but to the population. So that's why the issue is about, we will have to utilize the same resources that are available. I think I've been very clear that we can't create unnecessary expectations that are not there. We are saying that there is going to be resources that are provided for the judiciary, especially, for example, you'd have found that when the cuts were done, the parliament didn't see cuts, but because the financing or the budget of the judiciary was sitting in the Department of Justice, and therefore that was cut, which shouldn't have been. So the allocation within the same pie, we're going to have to be able to share. But there's been an acknowledgement from the Minister of Finance that there is a need for increasing resourcing, closing the gap in terms of where it has been. But all of us, it's almost like you're going to still have to rob Peter to pay Paul, because there's no additional resources that is going to come anywhere else. So if we redirect, we'll have to redirect from other resources. And one of the issues I shared with them, for example, as we were presenting and we were looking at the model of support, you would note that this year when I arrived, one of the issues that I did utilize, though the judiciary does not have a handbook We also believe that they should develop a handbook for the judicial officers, office bearers, the Chief Justice, the Deputy Chief Justice. So what I did, I utilized the framework of offices of ministers and deputy ministers as a way of saying they can appoint in the similar manner the staff complement to be able to support them. But I was hastened to advise them not to follow the ministerial handbook because they will lose a lot of benefits as judges. Currently, as ministers, you'd know over time because of cost containment measures, a lot of benefits have been taken from ministers. If you stay in a state house, then you must pay for the rates and for the water, electricity, including the water and electricity that is utilized by statics, those who are providing and those who are cleaning. So that's why majority of members, I was sharing with them that majority of members don't stay in state houses as ministers and deputy ministers. Similarly, in terms of travel, we provide more support for the judiciary, which is not provided for the ministers in terms of and those things. If you move into other provinces, what happens and all those things. So it's what I was sharing with them to say, let's look at what you have as benefits currently and not go into saying you want the same benefits, because you might have the old version of 1994 of ministerial benefits or 2000 of ministerial benefits. Whereas the handbook 2025 is different. The car model that they use and the car model that we use, we can buy with about 800,000. They are able to buy a car of more than 1.5 million. So those are the difference as well that we are saying. But we are saying ourselves is that we're willing to give, but as well within the budget, I think correct observation is that we have the same pie. It's not two pies that we have. As the country, because this are the resources of the country. And that's why the consultation will be able to lay bare to say, judiciary, this is what you will get out of this money. The rest of the money, where does it go? So that they satisfy themselves. If money goes to grants, it goes to housing of the people, it goes to defense, it goes to police, it will be outlined upfront. And we can't shorten those to also fully say we want to give all the money to the judiciary. Then you create an unequal society, you create a society, and you can actually set up the judiciary against population, because people will be angry when they don't get grants and they're told that the money has been paid to the judiciary. So you don't want to create that situation. So that's what I'm saying. In what we have and where there are gaps, we'll be able to. But we do think that there is a reasonable issue. One concern, though, I must say upfront, is it's the capacity of the judiciary that is going to have to be built over time to be able to manage these things. From the executive, perhaps we can say over time we've learned through mistakes, learned how to safeguard the issues and all those things as part of oversight. It will be new for them, but we hope we can be able to protect, the issues of corruption, the issues of that. And it will be difficult for us as a country if we have to deal with mismanagement of funds in terms of procurement in the judiciary, while the matters will have to go to the courts as well.
Yeah, no, I think that question of opening the door to magistrates and judges being challenged on administrative issues, because now they're obviously challenged on the decisions they make in the court, and this would open them up to being challenged on the administrative issues in their courts, and one wouldn't then be able, as a judge, to point to the Minister of Justice as being the person who's responsible. There's so many parallel systems well, I mean, not exaggerate. I'm thinking of one parallel system in the judiciary, where you have both the Magistrates Commission, which deals with the appointments and holding to account magistrates, and where there's one system for appointment, and then of course the Judicial Services Commission, where Minister you've been sitting. Would you envisage those as remaining for both magistrates and judges, or would you imagine something that would look at judicial officers down the line, or are we not there yet?
I don't think we are there yet. One is that in terms of level of work, the conditions, you'll still have to continue with the format. To reform something like that, it will take us some time, and you don't want to prejudice the others. But I guess once we have transferred, it will be the judiciary that takes its own decision to say, how do they want to function? How would they want to operate? And I think that would be, from our side, would have to support them. But I think in the immediate time, the current format will continue. And I think for me, always is that if it's not broken, why do you want to fix it? Because it might be working better, even if the judiciary is single. It's a single judiciary. But to have that, you can imagine if you have one that has to do with the appointment of 170 magistrates, and the other side you've got to appoint what is it called, judges. Now, will you have time to do anything else? And judiciary. So I think for me, where things are working, it could be just to take them under the judiciary, have them to be monitored, oversight, reporting under that part instead of in the executive. But you can still remain with them. That's what I'm saying. Where things are not broken, I don't think we should fix them.
I mean, you'll know that at the one of the sore points, and in fact, it came up in the Magistrates Commission in this last week while I was sitting in on those interviews. The magistrate from a court in Lichtenburg was saying that they are managing their sort of infrastructural issues. They have water tankers now because the water provision isn't reliable, and they're also using mobile recording systems in the courts. So for when there's not electricity, and so they're making a plan and they're getting it done, but it's clearly challenging. A lot of those issues around court infrastructure have been dealt with by the Department of Public Works. And there's this sort of tension between whose budget it is and what can the court manager do with their own budget, and that budget has been increased, we know. Is that something that's come up in the discussions so far?
Yeah, the Minister of Public Works and Infrastructure has been part of the conversation with us, with the President. I chair the ministerial team, which includes all of them: Public Service and Administration, Minister of Police, Minister of State Security, Minister of Public Works and Administration, Public Works and Infrastructure, and Minister of Finance. So all of us are part of the same process. When I report on behalf of the executive, including all of them. Now, with what has been happening recently with the challenges around infrastructure in courts, we did take a decision that we want to make sure that all our courts have a tank, so that when there is no provision of water, we can be able to provide, including generators. It has been approved. It has been implemented in a phased-in approach in terms of the budget availability. You know that for this financial year, we had made an application of 1.6 billion for finances just on infrastructure, both building new courts, fixing the ones that are there, but providing the alternatives that we need to do. And we were only provided with 400 million. So that's one of the difficulties. Minister of Finance has said to us, we'll relook at the budget. We're hoping with the medium term there can be redirection of budget funds to us so that we can expand the work. So that has been another issue that we have started looking at in the recording, was that we should be able to find recordings that can be charged overnight, gadgets that can be charged overnight, so that if there's no electricity, you can still proceed with the court processes and recording. So that is part of what we are working on.
Yeah, because that's obviously something that people have been talking about. And another thing that you won't be surprised if I raise the question of security in courts.
Yes.
It's something that's obviously particularly concerning. I'm in the Western Cape, in Cape Town, and you'll know we've had some incidents around courts here. And that question of security is a difficult one because there's so many moving parts in the system. So between SAPS and then the security services, at the perimeter of the court, and then once you get into the court, the different role players, you know, including SAPs and correctional services and court orderlies. Is this something that I guess from what you'd be saying that it would really be handed over to OCJ, but SAPs would still play a significant role there? Is that sort of how you imagine it working?
What we are doing, look, the issue of protection will remain. Even if we transfer to the OCJ, the mandate of SAPs can be transferred. It remains that of the Constitution in terms of protection of the citizens. So that remains. And that's why when there was the last incident, the Minister of Police, Deputy Minister Nel, together with the Judge President, were together in terms of the visits, engagements, and all that. Next week, we've agreed between ourselves and Minister of Police to have a bilateral meeting between the two departments so that we can be able to look at how do we collaborate, how do we support each other. And Minister of Police has said that he had committed to the communities in Western Cape that he will come back so that we can be able to say this is how we are intervening. So we are looking at that. It's something that we are worried about. The security in the courts. In many areas, we have been able to review our security measures. You'd understand that because there were not much incidents, so you'd have at a particular level of security. Now, with what we are seeing, we had to review our implementation of security, not only in terms of structures, but even protection. Protection of magistrates, protection of judges, protection of prosecutors, security at courts, including cameras, including the scanners, making sure that the scanners are working. So it's those things that we had to look at. Again, increase of budget, because this was not something that previously in the years past was an issue at courts. You'd not have people attacked in courts. For some reason, we are finding it now, and therefore we have to change in terms of redirecting the resources and making sure that we have the money to be able to protect the people.
Minister, I mustn't monopolize you. I'd like to continue asking you questions, but let me hand back to Mbekezeli, and let's look at the questions in the room and see what we're looking at there. I haven't been able to see the questions in the chat, but let me hand back to Mbex.
Thank you so much, Alison.
Mbekezeli, just note that the host has closed my video.
Oh, I don't know how. Sorry about that. I don't know how they stopped
but we can
video.
proceed.
Wait, is your video on now?
No, but I can speak. No, you can,
okay.
You can take the questions.
Okay, Jenna, please fix the minister's video. We've actually having a bit of a problem. I don't know why the Zoom today is not doing what it's supposed to do, but the Q&A, the chat function is not working. People can't see it. I can see it on my end, but people on their end can't see it. We've been frantically trying to fix it in the meantime, but I don't know why it hasn't been functioning as well. And maybe I'm going to ask people to raise their hands if they can, or actually it might be better if people can send me their questions. My number is on WhatsApp. My number is 072-325-8661. I'm going to repeat it again, 072-325-8661. And I will ask, I'll get the questions on the WhatsApp chat. But I do already have a few questions that I picked up from your discussion with Alison, Minister, that I would really like a little bit of clarity on. You mentioned that one of the things that is proposed is the full transfer of the functions or the lower courts from the DOJ, currently the Department of Justice, to the Office of the Chief Justice. That would entail that would include some of the, you mentioned that it would include the salaries and working conditions of magistrates. And I know that currently the terms of the magistrates are different. I mean, yes, they are determined by the Independent Remuneration Commission, but there are issues such as pensions, which is something that wasn't necessarily, it's different from how it applies for judges. Judges get a salary for life. And so how would it work for magistrates when it comes to salaries and conditions of service? That is something that I would like to ask there. The second, I think you've already highlighted and you've anticipated, is the question of accountability. Because as you rightly mentioned, the issue of procurement and how irregularities that crop up sometimes in procurement is a risk, especially if those same procurement issues will one day be in the courts. I mean, recently we have an experience of in the OCJ where there were irregularities regarding procurement, and that issue had to go to courts. So is that something that you have applied your mind to? I would love your thoughts on that. I'll ask those two for now, and then I'll come back with a few more.
Okay, my video is back now. Thank you very much. I think the first one, salaries and conditions of employment of magistrates, is still not the ambit of the minister. It's with the independent body that looks at all of us public office bearers. So we wouldn't be, it's not going to be affected. I think my assumption, because it determines ministers' salaries, council, your judges and your magistrates. So I don't think that will be affected. I think that will continue in that way. So whether which way we go, it will not be affected. So it will continue where it is, where there are issues. And that's why when they raise their issues in terms of their pensions, where it's sitting, I was clear that it's not my decision. It's the decision. They must be able to submit it with what is it called, the commission itself. With the risk that you mentioned around procurement and risk of irregularities, it's a risk that is there, and that's why we flag it. But it shouldn't deter us from ensuring that there's a full independence of judiciary and the responsibilities are transferred to the judiciary. I think it's something it's good that we are flagging it so that it can be something that we start paying attention to it, building capacity, and making sure that the work that will be done there is protected, but also getting the right people to be able to do a high ethical standard as well. But as well to say, if something like that would have happened, how to deal with it. And maybe we can take lessons out of the court online procurement process, how it was dealt with from the OCJ, and it did end up in court, and also how it was handled. It could be something that we utilize as a model to be able to deal with it. Thanks.
Thanks, Minister. So the other question that I would like for us to maybe ask, well, let me put it this way. Other question I would like to ask is, currently, as we speak today, we do have some challenges in terms of resourcing of the courts. I mean, we know that we don't have enough judges for the population that we have. We know that we don't have enough magistrates for the current population that we have, including the support staff. Now, you mentioned earlier that the resourcing will be the same. The judiciary will draw from the same pot. But I think one of the things that maybe you would have been able to do a little bit more effectively is sort of manage that political aspect of it, right? Resourcing, determining where resources go, is something that I think maybe people in the executive, treasury, and perhaps the people who write the actual budgets, those in parliament, are much more maybe experienced in doing. Particularly if you look at models around the world where we've seen, for example, in Kenya, they have a similar independence model as the one that is proposed. But the sticking point has been that the judges are sort of butt heads with the politicians over the resources and how much resources are enough. So if currently we are having that challenge, and maybe I think a lot of people in this room would want to hear what is currently happening even in the current framework with the resources and increasing the number of judicial officers and staff that we have. How is that going to be handled in future when we move on to the other phases of the proposed model?
No, the current framework, I don't get involved in the appointment of the judiciary as I get involved as a panel member in the JC. So the determinations of vacancies, how we fill the vacancies, is driven by the Chief Justice particularly. And similarly with the magistrates, is driven by the Judge President as the Deputy Judge President of he's acting now, acting Judge President of the Gauteng North, in terms of the posts that are there and to be filled. And one of the experiences when I got here, for example, is that when we looked at the magistrate, it was not that really the issues of budget, but we are not filled the vacancies. So they've been able to fill the vacancies. Similarly, as well, and arrived, the Chief Justice says to me in February, Minister, we have capacity issues. We're looking to appoint more people. And we say, okay, we'll ask for resources so that from the 1st of April, you have the resources. How many posts do you need? And then we got the money for 277 posts. But within a financial year, there's still difficulties of not being able to fill the vacancies. And I've been on their case to say, we can't have the money going back to Treasury or filling the vacancies when we've said that we have vacancy shortage. And part of the issue is that at some point there was misinterpretation of the regulations that were issued by Public Service and Administration together with National Treasury, because they thought that it's a standstill of recruitment. Whereas you could recruit, all you needed to do is to prove that you've got the budget at that time of the post that you needed to fill and therefore submit to Public Service and Administration for authorization, and that you would have been able to fill. And I shared this experience because I filled posts where I was deployed as a minister previously in my previous portfolio. So I was able to do that, and I knew that you just needed to comply with the process and to avoid over expenditure on cost of COE. Now, within this process where we are, and in October we'll be filling vacancies. I mean, I've said in JC this year. And my observation, for example, we had posts in Labour Court, I think about 3 of them, vacancies, but we could only fill 1. So it was not a matter of non-availability of funds. It was that the candidates that came, the shortlisting, didn't give us enough people to be able to appoint. So you sit with that money. So it's many factors that you can deal with in terms of that capacity. Similarly, in terms of the courts, lower courts, as I say, our superior courts, we've been able to sit and say, where are the vacancies and all that? And then get the team to focus on recruitment and being able to sit and do the interviews and recruit and fill those vacancies that have been funded. Similarly, you go to lower courts. I mean, I had to do an analysis, and where we know that there are challenges where we didn't have enough resources is around court interpreters. Many of them have been temporary over time. And one of the issues that I'm looking at is how do we close that gap? You go to legal aid, we do have, because for the courts to function effectively, it's not about the judge and the magistrate arriving together with the class and the registrar. It's the entirety of the justice system. So you look at, if you don't capacitate and have enough legal aid representatives, you don't have court interpreters. Even if you can have enough judges, the court is not going to sit. Because if I come and I'm an accused, I'm looking for an interpreter, there's no interpreter, you've got to postpone the case. So it's those things that's why I spoke about. There's still one pie that we've got to look at in terms of resourcing, because it has to address, even within the justice family, it still has to address all these issues that are there, which all of them, as we speak, are actually constrained. If I look at the budget, we had about 2 billion of cuts or more of cuts as a portfolio. That's a huge gap. That's a huge hole to be able to fill. And part of the issue that I've been looking at is to say, where do we redirect funds? What are immediate needs? What is priority? even on the repair and replacement, we were saying, do we have to go into contract and find service provider to do this work? Can we find people to do it? But when your ceiling, your COE has been put to say you must not pass here, even when you have that need, you can't be able to. That's why you end up with a lot of procurement under goods and services. So it's a whole lot of how do I put it, institutional constraints that we've got to be able to deal with, share experiences with the judiciary to say, look, when we took this approach, it was because of the following reason. This is how you can avert. This is how you can be able to build capacity, but also how do we address the issues of the cost? I think we're starting to see a turnaround around the maintenance, the provision of what we call the water provision and generator. But again, we had to address it with public works because, I mean, in one area, I asked them in terms of, okay, why don't we put boreholes? It's in Limpopo. I was in Limpopo. I said, look, my family comes from Limpopo. I know quite a lot. In many areas, boreholes work better. So let's do a borehole. And then they wanted to do a whole lot of feasibility study that is above $1 million. I said, no, but a borehole would never charge you even more than 200,000 to put a borehole in an area. So why do we have that? And then if you have to connect, I mean, it's a borehole drilling. And then because you have to connect the pipes into the building, it can cost you that amount of money. It's those things, the tank as well, it can cost you $1 million. So it's those things that as well, money is there, but it's the effective use of money. And I always say to people, I said, you know, sometimes you say there's no money, but money is wasted. And we've got to be able to say, where are the areas of leakages? Where are the areas of wastage? Can we save and be able to redirect it at the right side?
Thank you, Minister. There are people who want to ask a few questions, and like I said, the chat function isn't working as well as it should today. So I'll remind people to please post the questions to my number. My number is 072-325-8661. Again, 072-325-8661. Minister, I wanted to follow up on the last question. You're right, the recruitment process is probably not as efficient as it should, in that, for example, in the last session of the JSC, there were posts available, but the candidates were not suitable. I think that's a challenge for the JSC, and it's something that we have raised for many, many years, that the way that the process currently runs, the way that the interviews are currently run, it actually is repelling suitable people from availing themselves for appointment. So that's a challenge maybe for the Chief Justice to address with the collective of the JSC. But the question I was asking was going to a different direction, Minister, in the sense that, for example, in Gauteng, there are about 80 judges in Johannesburg and Pretoria, and there have been 80 judges since 2009. We know that the population of Gauteng alone has grown by more than 50%. The population in that province is causing some of the workload of the courts to go up and quite at an alarming rate, but the judges remain the same. So the posts that are available in Gauteng are still the same as they were 15 years ago. So part of what that response has been when the judiciary and us in civil society, when you've asked questions of the executive, they said, look, there are budget constraints, and for us to create new posts, it will be a challenge for us, and which is why there was a Moseneke committee on rationalization to look at that. As I understand it, that work has been finalized. So what is the current status? What are the plans to increase the number of posts? Because I think that is the bigger challenge. So I think if the posts are created and there will be a culture of suitable people coming forward and posts not being left vacant.
I disagree. You can't say that you must create posts to fill posts that are existing and are not being filled, because that's what you are saying. But no. Because the issue is we do have a challenge, and I acknowledge it. And that's why you are acknowledging that we had, and it's not, when I asked, it's not the first time. There's been times where individuals have come forth 2 interviews, you find that there's no suitable. Instead of 5, you fill 1. That is another problem. So filling the current vacancies is important. And for me, it's important because an acting person, you can't hold them accountable. Judges who are sworn in, when they do wrong things, you are able to take them through the JSC and they can be impeached, including the magistrates. So that's why permanency is important. The second issue around the rationalization, yes, the report has been done. I've met with the former Deputy Chief Justice. We are taking the report to Cabinet, and I'm looking at making announcements around the implementation before the end of the year. So latest around the end of the week of November or first week of December, because I do think there are quite good proposals in those reports that can help us, both as executive but as a country. Quite fascinating proposals, if I may say, which I fully agree with. But I have to go to Cabinet because I'm acting on collective to be able to appraise the Cabinet in terms of the work that has been done, proposals that are there, including, I mean, when you look at issues of access to justice of people as well in the rationalization is what we need. So it's not only about the number of judges that must be appointed. It's also quite a lot of issues. I mean, proposals around recess to deal with backlog, and the rationale of how we ended up with recess in courts, the issue of infrastructure, the number of judges. So there's quite a lot of issues that are there, which we do agree with as part of the rationalization. That's why I'm saying before the end of the year, those will be released to be implemented. And we're looking forward to implementing those recommendations.
Thanks, Minister, for that response. So there are questions that have already come in. There is a question from Advocate Laverne Akom from the Northern Cape in Kimberley. They are asking about the court online process. Currently, there is a rollout in various provinces, but the problem is that there is no Wi-Fi in the courts. So it's well and good to have a court online, but if you can't access the court online when you're inside the court building, it seems to defeat the purpose. So the question is, what in the new framework, how will this work? And even currently, it probably is a function that resides with the OCJ, but it's would you have a comment on that? The other question comes from Clifton Massetti, who's a regional magistrate in the Western Cape. And the question is asking, why is the transfer of magistrates not included in phase 1? And why is it left for phase 2 when the conditions of service of magistrates seem to be a burning issue right now? And then the other question is, why are magistrates not provided with the same level of security measures as judges are provided? There seems to be a disjuncture there. And this links up with another question, and this will be the third question, and I'll ask you
You don't read it too fast, Nick.
Oh.
You are reading very fast.
Very fast, I'm sorry. Okay.
So the last one you were saying, I was trying to understand that one.
Yes, so the last
because
one.
I picked up the issue of Wi-Fi is fine. The issue of why the transfer is phase 3. Yeah. And
then the last question is, why are magistrates not provided with the same or similar level of security? And maybe just to combine this with another question that was asked is, what are the measures to protect judicial independence at the lower courts? Because there have been incidents where, for example, a magistrate's face and their picture was posted on a news story, and that later made its way to TikTok, and the magistrate has been subject to some level of cyberbullying, and some of those, that antagonism has reached the magistrate even in the courts where they sit. So what are the measures to protect judicial independence from that perspective as well? So the security measures is why are magistrates provided differently? And a practical example is this magistrate who was subjected to cyberbullying. I think it's a magistrate in the Western Cape as well. So I'll end there. And then I'll encourage again people to please send through the questions. The number is 072-325-8661. Thanks, Minister.
Okay, let's start with the issue. I do agree that if we are to modernize, we must be able to roll out Wi-Fi across. And as colleagues would have picked up, one of the weaknesses in the portfolio has been within the IT system. So we are fixing that to ensure that all our IT facilities are literally functional optimally, so that we can be able to ensure that all of us are able to work in a digital environment that enhances the support of our work. So that is one thing I agree with. We've got to be able to roll out so that at the courts as well, we can be able to access. I do think that is not only in Kimberley, but across many of our courts. And when you have access to internet, sometimes it's very weak as well or unreliable. So we are attending to that one. On the issue of phase 3 transfer, we proposed that we wanted to transfer. So it's between, and maybe let me start by saying, we agreed that we needed to, I've asked the DM, because in terms of magistrates, it's delegated to him, to say, can we start engaging with the magistrates on the transfer, on the condition, on what we want to do as part of single judiciary. From our side, I can say, we do believe that this can be transferred, but because the number of employees that are supporting the lower courts are employees of the Department of Justice. So there are conditions for us to be able to transfer to OCJ has to go through the bargaining council and also has to go through labor. So it's not an easy task for us, because that part of the lower court was fully, I can say, except for the magistrates to a larger extent, but fully under the purview of the Department of Justice and Constitutional Development. So looking at what needs to be done fully, it meant that we would not be able to effect it with the 1st of April, 2026. Like with the superior courts, where a lot of responsibilities were already sitting with the judiciary. I think we were left with few that we needed to just make sure that they are with the judiciary. And that's why it's easy to move with that one to the 1st. But secondly, for a function of the magistracy to go out of the Ministry of Justice, it needs legislative amendments. Therefore, it can be done by the 1st of April, 2026. So we need to go draft the legislation, consult on it, and take it to Parliament. So that's where the issue is, and that's why it's at the last phase, because it needs legislative amendments for us to be able to do that. Now, I'm not so sure about provision of security. What does it mean? But what my understanding and my issue is that where we have, and I think those issues are going into, unless if it's the issue of condition of service, which I do not determine as the minister, nor does the department. It's the commission that determines the conditions of service of magistrates. And where there are differences of conditions of service, so magistracy has to take it up with the commission to be able to change those conditions. I do not have the powers to change those conditions. And I can say even now, even if we are to transfer, those conditions have to be negotiated through the commission and therefore agreed upon at that platform so that they can change. So it's not something that I do, I don't have powers on. They can be changed in that area. That's why even on remunerations, I don't get involved as a Minister of Justice. So it's the President, it's the Commission, it's Minister of Finance, not Minister of Justice at all. Neither remuneration or conditions of employment of the judges nor the magistrates do I get involved as the minister, or any, even my predecessors never got involved. So that's the issue. And then on the issue of protection, where we do pick up that there are challenges, we do raise it and then we protect. We've had magistrates that lives are in danger that we have been able to protect in terms of cases. The issue of cyberbullying and others, for example, I think that one is not really about the independence, because it is the courts that determines the broadcasting of the cases. And it's not the executive. We don't take that decision. So you find that when a broadcasting of a case is happening, the broadcasters show the face of the magistrate, show the face of the prosecutors. And even that's why you'd have heard that after the killing of Tracy, and many of the public prosecutors under NPA that had their lives had been threatened, we called for the broadcasters to stop broadcasting the faces and also just have the transmission of the voices when they broadcast, because these are unintended consequences. So we have agreed, I've reached out as well. Yesterday I had a media roundtable with on the JC as a JCPS cluster chair, and we've agreed with SANEF that we'll have a meeting where we can look at mechanisms. They don't want us to regulate it, to put it as a law or as a policy, but they said, can we have a meeting so that we can be able to engage? So the issues are beyond that. We don't determine what happens in the courtroom as the executive. It's the judiciary that has full powers of what happens inside the courtroom. And therefore, the judiciary can make those decisions to say, while we are dealing with this is how you can be able to broadcast. It's the judiciary that can determine how transmission of information out of the court is done, not the executive. Thank you.
Thank you, Minister, for those responses. I think on the last bit, we agreed on responsible reporting is very important. And so one of the plans that we are hoping to roll out in the next couple of months is maybe training and sensitization of our media colleagues in terms of how they can responsibly report on the courts, because they are an important accountability pillar, and that's something that we should emphasize. And the next question comes from a journalist, actually, Anastasi Makhobu from Jacaranda. And the question is on the postponements that are caused by minor infrastructure issues. So they, as journalists, they sit in the courts for a number of times, and they experience a lot of postponements for relatively trivial issues. So the question is, how can the work of the courts not be disrupted by the minor issues? And maybe just to anticipate and link it to something you said earlier, is that one of the things that will remain, even when the transfer of the court function moving into fully under the judiciary, one of the things you'll retain oversight over is the functioning or access to justice. And I think this is an access to justice issue. So maybe if you could give us your comment on that aspect. And then a second question is on it's by Den Mafura from CASAC. And the question is whether the Chief Justice, it would be enough for her to appear twice a year in a joint sitting of Parliament to table a budget, and whether there is an opportunity for her, or there is scope for her to account through the Justice Portfolio Committee, I'm assuming also the Select Committee in the NCOP and SCOPA. Because I think what Dan's question is going to is, when it comes to accountability, currently, you have to go to Parliament, and the Portfolio Committee asks you difficult questions. Now, what you've suggested is that the Secretary General of the OCJ would be the one to go and account, but I think the PFMA requires the executive authority to do that accounting. So how will it look in the proposed model? And how will the Chief Justice, what will the Chief Justice's role be? And then a third question, and I should also just flag here that we don't have a lot of your time, Minister. We've taken a bit of time. So we're going to wrap up in the next maybe 15 to 20 minutes. So I'll allow for just a few more questions, but also, Ministers, just so that we get as many questions as possible, if you could give us as brief as answers as possible, because they're extremely important. So those are the two questions that I've asked for now. I'll come on with the next round of questions. Thanks, Minister.
Okay, I'll try my best to be as short as possible. The issue, I think the Dan's question on Kazakh, I did deal with it. We haven't finalized the model. So it will be in the discussion with the judiciary. Some of the proposal is around a committee that can oversee, but the issue is that we've got to have an accountability model. Somebody actually said, I can't remember, one member of Parliament said, the Constitution says the judiciary must account to itself. meaning they can't go to Parliament to account for the finances. I said it will be disastrous. It will kill public trust. So it's those things that we've got to find mechanisms on. And the team is working. We're looking at various models across the world to see which model can be proposed. And once we are ready, we'll be able to make that decisions. But hopefully, as we do the engagement with various bodies, you will assist us in terms of the research that is there done. CASAC remains quite important, and also most of the colleagues who are here in terms of inputs. On the postponements on minor issues, yes, I do agree. There are various things. What we have done, we've done case management processes. We are monitoring across the country when cases are postponed, what are the reasons? And I can safely say it's not every time when it's electricity or water. We've been able to put those as alternatives to courts. Yes, not yet all courts that we are finding. And I can tell you that, for example, if you deal with Children's Act, Children's Justice, Children Courts, you find that because there's not been a psychologist. So it's quite a lot of things that we're starting to pay attention to per court to be able to address so that there isn't a delay in justice. So those will continue to monitor, because for us, the issue of access to justice, and when you look at the Constitution, the responsibility that the Constitution bears on the minister responsible for justice will remain, and that is agreed to, that can be removed, because it was in the best interest of the country to have those checks and balances. Thank you.
Thanks, Minister. The questions are coming in thick and fast. I'll try my best to go through all of them. But you mentioned that the proposed model, when it is implemented fully, there will be a single judiciary. The question that is asked by Magistrate Betty Rohit from Durban is, do you agree that magistrates are judges, and therefore the governance of lower court judicial officers should be incorporated under the Constitution directly and not through the Magistrates Act? There's also, I think, people who've asked the question about, will now magistrates be called judges under the new model? What is your comment on that? And then the other question is asked by member of SALA, Ms. Kwinana. She's asking about the rollout of court online in the lower courts. Is that something that will be included as part of the shared services that will be transferred? What are the plans regarding that? And then this also links with a question by Advocate Karen Stradom from Pretoria, which is the question is now escaped me, but the question is on the idea is that in the proposed model, the move of the lower courts, the magistracy, into a single judiciary, that would also mean resources move. And I understand when I looked at the budgets this year, that might be about 45% of the current Department of Justice's budget. Is that what will happen? Does it mean that going forward, the DOJ will be slimmer? But I think the real issue is on the resource question. How much more will this new model benefit in terms of resources available? That also is a question that is asked. Over to you, Minister.
Yeah, let me start, because I've already answered the resource question, colleagues. And I'm not fussy. I'm not one of those that are fussy about that my department is big, it's got this big budget. It's about the work. Those who have known me have been responsible for communication, and the staff complemented communication was 75 people. As a minister, I was responsible for tourism. You look at the budget of tourism, I think it was about 3 billion. So I'm not fussy about, I'm not a fan of big budgets and all that. It's about functions. It's about the responsibility and what you can do to transform society and make an impact, but to fulfill the constitutional obligation. That's what it means. We have not extensively finalized the model of the magistracy, because this has to be done in consultation with the magistracy. I'm meant to have a consultation session with the regional heads so that we can start putting in the proposals, and they will be able to make those decisions. Some of these issues, colleagues, are as per the Constitution. they would not be able to be amended by the minister. And if they need a constitutional amendment, they need to go to Parliament. And I must say that 2/3 majority for an amendment of a constitution is not a small play in Parliament, especially in the current Parliament setup with the GNU and parties. So the interest in terms of dynamics are very, very different. And therefore, the outcome of 2024 does present its own challenges, own opportunities, but also more challenges in terms of having a cohesive understanding of what needs to be done and amended. So I always say to people, when you need 2/3 to amend, you've got to go there when you know it's absolutely necessary for you to go and amend the constitution in order to make a particular effect, because you're not going to get that number majority of the time. It's only when you have a consensus matter across. And I can tell you now, on matters of the judiciary, I don't see us having a consensus. There are people in the Parliament who have a view that the current judicial mechanism it's liberal, and therefore they would not support it. So you need the numbers in Parliament to be quite reflective of what you want to do. So that's the issue there. The shared services in terms of the court online, we are looking at having that. We are conversing. It's just that they were starting with the superior courts. They've not finished all the courts. They were working on that. And then we'll have a conversation in terms of rolling it out. It's a good system that is very effective. We do believe that it can be. But as you know, currently it's a system that is only on civil matters. But we can be able to look at it in terms of online at the lower courts. As we are saying, we're working on a phased-in approach. And I must hasten to say, would appreciate support and inputs in terms of what can be done. The question whether magistrates will be called by judges is not for me to make a decision on, or it's not for me to opine on. I do think the judiciary can decide on its own, as it takes over the independence and the single judiciary, how they want themselves to be structured and how they want themselves to be operating. That will leave it to the judiciary. My responsibility is to be able to give effect to the institutional independence and for the civil judiciary, therefore transferring the responsibilities and the functions to judiciary, and judiciary organizing itself and also determining its operational procedures for itself.
Thank you very much, Minister. This will be the last round of questions, Minister. I think we don't want to keep you too much away from your family. We understand it's a Saturday after all. You also deserve to spend time with them. So I'll just ask one final round of questions. And the first question comes from Leila Limbata, who's a district magistrate in the Eastern Cape. And she's asking whether the project plan, which will involve these different phases, will there be interim reviews to ensure that there is follow through and prevent the initiative from remaining only on paper without tangible implementation? So that is, I think, important, because these reforms to the judiciary has been spoken about since 2004 at a judges conference in 2004. We are now in 2025, and we're excited by the movement over the last 6 months, but it's been a long time coming. And you can also give us an update on how far the task team is, because you mentioned that some things will be introduced later in the year. You have to run them past cabinet. So how should we manage that kind of the process? What should we expect from our side, and to manage our expectations? And then the second question comes from Tirusha Naidu, who's actually my colleague at Judiciary from the African Lee platform. And she's asking about access to information and the difficulties in trying to get judgments, because African Lee publishes the judgments and other legal documents from the courts, and how can it be easier to get access to that? And it touches on this issue of access to information. I can link it with a question that has been asked by a lay litigant it's Ms. Sushila Rambali, and is asking about court records as lay litigants. She says that access to court records is vital for transparency and fairness, but the magistrates court staff are denying access, even though the High Court easily allows access to court records. And she says this is important because lay litigants are not awarded costs for transcripts and other court records. So how can the magistrates court make it easier for them as lay litigants to get access to those court records? And I think, yeah, the access to information question we can put together. Now, this is the final question, and I will apologize to those who've sent more questions. Right now, our time that is available, unfortunately, is not that great, but I think this is motivation for another session, Minister. So please keep us in your diary. The last question comes from Zolega Godashe, who comes from Newsroom Africa. She's a journalist. And she says that JOASA has previously complained about issues of the lower courts, and including in the Randburg Magistrates Court, the disappearance of court files, which undermines the administration of justice. And so how urgent are these reforms to try and relieve some of the burden of the lower courts and to avoid issues such as the disappearance of court files? I think this is the question about the rollout. I mean, it also touches on the rollout of the court online system. So I will pause there, Minister, and allow you to respond to those last three questions. And maybe in your final response, you could also shed a little bit of light in terms of how best can there be more engagement of this nature with civil society, with with organizations within the judiciary and legal profession. I think the questions are so many because people would like to hear more of you. So, Minister, over to you.
No, thank you very much. I think let me start with the last one. My team will definitely do. I've been engaging. I'm one person that doesn't stay in the office quite regularly. I've gone to sessions where we engage and make time on them. So I do commit Mbekezeli that I would have a follow-up session on this matter. I do think that there are quite a number of issues that we've not been able to touch, and perhaps will limit me talking more and also just allowing for those preparatory mechanism for us to have a more engagement session potentially. So let me commit to one last one for this year where we can update. Let me start with the issue of how we are monitoring the work. There's been previous commitments of this, and yes, acknowledgement of the last 6 months that there have been quite extreme movement. We are doing quarterly monitoring. Reporting, we've agreed that we will meet quarterly, present the report to look between ourselves and the judiciary. So I will lead the team, the Chief Justice will lead the team, and we'll have the presentations. I'm going to Cabinet now in October. We were meant to go in August. There were issues that the technical team were not clear on or not in agreement on, because what I have done, I've set up a team between the OCJ and the department. For example, we get feedback that they are not ready on this, and I've insisted we have to implement what the President and the CJ have asked us to do. So I held a meeting afterwards, after the technical team, with the judiciary, to look at the progress, to give them updates. They made the input, and that's what necessitated us to have a review of where we are. We'll go to Cabinet to make the proposals, and then after that, I will meet with them to give them feedback of Cabinet, including what can be done. But we think we're still on track for the 1st of April in terms of some of the proposals that we've made, and as I said, quarterly. But another issue that we wanted to do, why we delayed the meeting and the submission to Cabinet, is that I had not had a meeting with the magistracy. So DM did present in the platforms of the magistracy, and then there was a feeling that they would want to engage with me. So they directly as the minister, so I've agreed to do that. So that's when we want to make sure that by the time we go to Cabinet, we've had the views of the magistracy and how they want to be affected by the process and what the intervention, so that we can share both from the judges and the magistrates in terms of the issue. So that's where we are. And what I can assure you, ladies and gentlemen, I am committed into this. That's why we've moved faster, and that's why we have timeframes. We have a roadmap very clearly on what needs to be done. And this we're putting in place so that it's not only Minister. One of the issues even I'm considering is to have a team permanently just looking at this and ensuring that it happens. Because the minute you start with transfer of staff, is going to be a lot. So you can't have officials who are going to be part-time on the project. You want full-time, and that's one of the issues that I'm considering to be able to do, finding suitable people to lead this project and make sure that it happens effectively. Access to information, I was not aware that the clerks and the registrars at magistrate level are refusing with information. Please do provide, we'll send out a notice to all of them. It's not allowed. They must provide judgments, because otherwise, how do you know what has happened? How do you, because it's about public information. A judgment that is made, even if you're not a litigant, or it's jurisprudence, so it affects you in the future when you do. So I will do a letter to all of them and notify them that they must make this information available, unless if there's a particular reason, there's a court order that says in that particular judgment it should not be made. But I don't think there's any. I know it's matters of children that we've got to protect them, but besides that, it has to be information that is available for us. But even for researchers, I mean, students must utilize what is coming out of those courts as part of understanding our legal framework and being able to build towards the other case. But those who are litigating as well must be able to utilize this information to be able to fight other cases. So I am going to write to them. I was not aware that is this happening. Newsroom Africa, Juasa complained about Randburg, and I visited, but it was not that. Immediately when I got that, the issue of Randburg, I interacted with the team there, as I do everywhere. The minute there's a complaint, I go and ask for a response. What had happened, and it's an unfortunate situation, is that one of the clerks actually had a mental breakdown, and the seniors did not pick it up. So in that process, as you know, when you have mental issues, he locked files in a particular manner where they were not accessible by anyone else. And when it was flagged with me, we went to check, but I can assure you the individual has received support from us as the department, and we assigned somebody immediately to redirect the files and the matter. They were not missing. The incident, I dealt with it personally. The files were not missing. They were meant, it was about 8 files that were meant to go to court in a particular day. And it was more around this individual. And we went and checked, we found that in the manner, because of situation that the person was going through, would just take files and go file them, put them in a lock safe where no one could access. And as he went to doctors and went to counseling, no one could understand, and because of the mental breakdown, would not even be able to respond to anyone or guide anyone or report to anyone that I'm not coming, the files are there. But we have provided support because we are obligated as the employer to provide support to that individual and reposition that individual in an environment that is conducive for them to work without affecting us. I did visit the court. We were able to see, and at the time I visited, I even checked the roll. Cases were there, and they were running in until the on recording at that time was that they've got dates for November. They don't have any new dates for next year of those that needed to be scheduled. So if there's anything that you know, particularly about the Randburg court, I would really appreciate so that we can support. So what I've done, I've opened up for everyone where if there's a challenge in a particular court, because not one problem is similar to another court. So we are able to attend to it, either myself or the DM, or even send the officials from national to go and see what is the problem while we're fixing some of the long-term problems. So we are sitting there and being able to say, this is what we are trying to do, but we need everybody to help us. In various areas, it's NGOs that have been able to help me. Give me feedback, especially around your maintenance issues, but also where they're doing well. I mean, I went to a court in Port Elizabeth, one of the courts that in terms of infrastructure is not good. You need a lot to support there. But one of the best performing in terms of maintenance, almost 100% of maintenance matters being concluded. The investigating officer is even training other investigating maintenance officers in other regions on how to manage, how to have success rates. So there are pockets of excellence in various areas. So I asked the magistrates to confirm how, and the magistrates were singing praises of this official to say the proactive manner that he deals with the issues. He's able to mediate, he contacts the people who are supposed to pay, and he's able to say, even when a person is in another province, follow up, make sure that there's a decision and all that. So there are areas where we are doing well, and supported by you as NGOs, by sectors, magistrates in various areas. I know I've not been to KZN to visit. I will do that. I see Northern Cape. So I can see the provinces I've not been to are coming up, Mbekezeli, up in terms of the issues. And I will definitely visit them so that I can interact with them. They can see what we are implementing, the responsiveness, but also where there are challenges of our officials, please don't hesitate. Drop an email. We'll be able to attend to it. I mean, I've been able to attend to issues that I've found on my Twitter, on my X handle, on Facebook. And we've been able to respond to them because we want to be responsive to support the judiciary, but to ensure that South Africans can have access to justice. We might not be perfect, but there's a lot of work that we are doing to turn around the image of the portfolio and ensure that there is performance and we can be able to serve.
Thank you so much, Minister. I'm really, really worried now that I'm going to get into a huge amount of trouble with your family. So I do want to release you to enjoy the rest of your Saturday and the rest of your weekend. But I would here like to take an opportunity to thank you, Minister, for making yourself available. This for us was a first. We're taking chances, and it's really incredible to hear that you are willing to engage and that you've committed to another engagement session. We hope to have it in the next couple of weeks, and that will be the last for the year. So we are thankful for that.
Let's do
that. Yeah, no, we will do it. We will do it before the end of the year, definitely. But for now, I would like to express our huge gratitude, Minister, for making yourself available. Would also like to thank our colleagues in the Ministry of Justice. I'd like to single out Mmamoloko Kubayi for working her magic to make you available. We'd also like to thank Mr. Terence Manasseh for his excellent work as well. I'd like to thank my colleagues in the DGRU, Jenna Mujin, who's been running around organizing this. Our director, Ms. Vanya Karth, my colleagues, Dimagaton Chodu, obviously Alison. Thank you so much for your excellent interventions. And I'd like to thank everyone who's been part of this session. It was a risk for us to call people on a Saturday, and I'm really impressed that so many people showed up. I'm sorry that we couldn't get to all of the questions, but as the minister says, we will have another session, hopefully in November, before Christmas at least. So let's hold the minister to that. And please do, if you can, do send your questions to us via email. It's info@judgesmatter.co.za. And we will try to keep these engagements going because they are incredibly important. I think this week has underscored how important judicial independence is. It's not something we can take for granted. It's not something that we can actually dispense with. It affects the day-to-day lives of all South Africans. It affects our quality of justice in the country, including our economic development. So it's something that we are really laser focused on, and we are glad to have someone like you in the ministry, Minister, who's active and who's engaged in the issues, because it does matter. So I would like to end there, and I would like to thank everyone, and I wish everyone, including Orlando Pirates, a very wonderful day. Minister, I see you are in black and white, so I'm sure you agree with me. But thank you very much. Have a wonderful Saturday, and yeah, we'll speak again soon. Thank you.
I'm a chief supporter, please. Okay, thank you very much, and thank you for inviting me. It has been good engagement. I really appreciate it.
Thank you, Mr. Thanks, everyone. Bye.